is now called to order. Roll call, please.
Yes, ma'am. Dr. Beebe. Dr. Beebe is present. Ms. Bopey.
Here.
Ms. Bopey is present. Ms. Bradford.
Here.
Ms. Bradford is present. Mr. Garvey. Mr. Garvey is present. Mr. Gio is not present. Ms. Hill.
Present.
Ms. Hill is present. Mr. Lee.
Here.
Mr. Lee is present. Dr. Moranti.
Present.
Dr. Moranti is present. Ms. Orange Jones. Ms. Orange Jones is present. Mr. Romer. Ms. Smith.
Here.
Ms. Smith is present. And Ms. Campbell, our student representative,
Here.
is present. You have a quorum.
Thank you. I'd like to take an item out of order, item 7.1. Yes.
So let's approve the consent agenda, if you don't mind adding items 3.1 and 4.1. Mrs. Bradford.
Shirley.
Need a
So
motion?
moved.
Second.
We have a motion taking
3.1
5.1.
and 4.1. The start item.
Who made the motion down here? We missed it. Thank you, Ms. Bopey. All those, do we have any objection to the motion? The consent agenda is approved. Now we'd like to take an item out of order.
So item 7.1, page 169, consideration of a report regarding the Battle of New Orleans educational curriculum presented by Lieutenant Governor Jay Jordan.
So moved. Thank you. Have a second. Thank you. Any opposition? I don't know what the noise is, but we're working on it.
Good afternoon, Madam Chairman and members. I know there's a lot of static in this room, and this time it is the microphone.
And welcome. We're glad you're here. We appreciate it.
I'm glad to be with you, and I appreciate just a couple of minutes of your time. We're in the golden age, really, of anniversaries for Louisiana. We had the bicentennial of statehood in 2012. We're celebrating the tricentennial of the first city in Louisiana, Natchitoches, this very year. We'll celebrate the bicentennial of the Battle of New Orleans next year, and then the New Orleans tricentennial will be in 2018. So we really have had a remarkable series of opportunities to provide educational opportunities for the young people of our state. And today I want to ask you to endorse this proposal, which is the Battle of New Orleans Education Program. And you have in front of you, I think, the booklet. This is a very significant battle in American history. It really replicates what we know about Louisiana in its early days. The Battle of New Orleans took place after the Treaty of Ghent had been signed, but the countries had not ratified it yet. The War of 1812 began literally a couple of months after Louisiana became a state, and one of the focal points at the end of the war was Louisiana, because here came the British trying to get another foothold in America by taking New Orleans. But it didn't happen because of a ragtag group of people led by General Andrew Jackson. And we all know that basic story, but there's so many historical components to it and cultural components to Louisiana that we tried to capture in this program. And the Battle of New Orleans Commission, which is chaired by former Congressman Henson Moore, has sponsored this effort. It's not going to cost school districts across the state anything. The commission's funding, which doesn't come from the state, but it came from some leftover funds from the bicentennial celebration, along with some grants that they'll be receiving in the not too distant future, are making this possible. And I want to recognize and thank the folks who've had a hand in it. Richard Hartley and Julie Wiesno from my office, who you've seen before with the other programs we brought to you. And in this case, we had Jason Weiss, who is the Associate Director of the Williams Research Center of the Historic New Orleans Collection, wrote the entire plan, but the lessons were designed by Ann Trappe, who is with us today, who spent many years teaching history at Kentwood High, has a very impressive resume regarding American history. She was a curriculum writer for Glencoe McGraw-Hill Publishing and has any number of other accomplishments. So we've had great educators prepare this lesson plan that is applicable to grades K through 12 with just a little tweaking by the teachers. It It has numerous sidebars of information. It's all in accordance with standards that have been put in place for writing and for literacy. So very much would like you to endorse this so that we can officially send it out to every school district in the state. It's going to be made available to everyone in education in Louisiana, public schools, parochial schools, private schools, homeschoolers. It can be found online at the Battle of New Orleans website, and hard copies will be distributed literally to every school in the state. So I'm grateful to the people who have made this possible, and we're looking for every opportunity in our office to be able to enhance the learning experience for young people in the state in new and creative ways. And along with what we tried to do with the bicentennial and with the Atchafalaya natural history area, and with this program, we think it gives the young people of Louisiana a chance to really learn the significance of the early days of our state. So I thank you for the opportunity to make that presentation. I would ask you to please endorse the program as we look forward to sending it out across the state.
Thank you so much. I need a motion to receive this report.
I move that we receive the report, endorse the report, and express appreciation to Lieutenant Governor for presenting it to us, and thanks for your preparation.
Thank you. And I forgot to recognize Mary Kader, who did all the design and layout for us as well. So those are the folks who really put the whole thing together.
Good job. I need a second.
I'd like to second. I'd like to speak.
Very good. Yes, I think it deserves applause. Are any questions or comments from the board members?
I have some comments. So, Ms. Trappe, I've seen your work since I was in a classroom teaching, so I'm glad to know that you're still contributing resources to the field. I would just like to recommend that it be targeted to the 8th grade social studies teachers. When you send things to schools and it's not targeted, it doesn't always get in the right person's hands. So if we can figure out a way to make sure that 8th grade social studies teachers are the ones that have access to it. And then I also wonder if you've been in touch with the Louisiana Council of Social Studies Teachers. Okay. And great. I just want to make sure that the right audience hears about it. So I'm excited to have an opportunity to look through it, and I appreciate your work.
Thanks. We'll definitely do that. Thanks.
Any other comments?
Madam Chair, I'd like to also express appreciation for Lieutenant Governor Darden for being such a good historian, presenter, joke teller. He even makes Louisiana look good.
He is truly one of our greatest resources.
Yeah. It's easy to do. Thank you.
Is there any objection to the motion? Motion carries. Thank you so much, and thank all of you for your hard work. We appreciate it. Next item.
So your next item is on page 8, item 3.2. Consideration of a request to reaffirm early childhood licensing waivers, and the department recommendation is to approve.
Do you have a motion? So moved. Thank you, Ms. Bofi. Do you have a second? Do I have a second? Thank you, Ms. Smith.
For lack of a second.
Madam Chairman,
Yes.
thank you very much.
Superintendent.
Members, just for context on this, the department is bringing over the entirety of the licensing function from the from the Division of Child and Family Services by October 1, meaning that all centers that are licensed to provide early childhood care and education services, be they private or be they public, will be coming over to the agency. Thus, it will be fairly regular for you to consider issues in this committee related to the quality of services provided for early childhood education and learning outside of LA4 or AG programs. This is the first such question. It's a small and not a huge decision, but what it does do, what we need to consider are those situations in which early childhood centers have received by the Division of Child and Family Services exemptions, and that those exemptions not be lost when those entities transfer under our governance. So what this does is to preserve those exemptions to licensing regulation that have been made by the Division of Child and Family Services already, and brings them over so that they're not interrupted come October 1st, as we do not have another board meeting until that time. I'm happy to speak to specifics. They are, as you will see, relatively narrow and very site-specific issues, but we ask your consideration and approval of them.
Any questions from the board?
I think I do. On page 10.
Ms. Beatty?
There are some in the description. In the description, these are reasons why there are requests for waivers, or there is a recommendation for waivers.
It's a description of the waiver itself, yeah. So you'll see some have to do with meal services, some have to do with exits from the building. Effectively, you're talking about hundreds of centers. There are exemptions to the standard regulations that have been made. They're applied for by particular groups, very similar to how you consider exemptions to the things like seat time or classroom teacher ratios kind of thing.
Well, Superintendent White, more specifically on page 10, items 19 and 20, when I read this, it just it gives me concern. Do I have the right interpretation?
Well, why don't we have Bridget address those two items?
So just to provide a little bit more information, I assume you're talking about the Child's Play 2 Child Care and Development Center and the YMCA Castle Kids. For number 19, the gentleman, so the current statute requires a state background check. This gentleman had a federal background check, and so that he did not have to pay to now get a state federal check, a state background check. Since the federal check is more extensive, they waived the state background check for him. So that's what happened in 19. Since he had a more extensive background check, he was not required to get the state.
Okay.
And on 20, this woman was convicted of fraud with a worthless check conviction. The conviction happened before the fraud regulation was written into the policy. She was already the director at the time. And DCFS looked through the application, determined that they did not believe that this had any bearing on children's health or safety. Also, the owner of YMCA Castle Kids is the one that handles all of the finances, not the director. And so reading through the application, considering that health and safety was not in jeopardy, the woman was not in charge of the finances of the center, and she was the director before the fraud, the regulations were written so that she could no longer hold the position with the conviction. They decided to make an exception on her behalf and allow her to continue to be the director. I will point out that we are asking you to reaffirm the waiver that's currently in place, and therefore when that timeline runs out, it would have to come back before this board, and you could reverse that decision at this point. So just a little bit of background information on those two.
Okay, thank you.
Thank you. Any other questions for the board?
Does this group include daycare centers as well as early
Yes.
childhood centers?
Head Start and child care, yes.
Any other questions? Hearing none, any opposition? Motion carries. Next item.
Next item is on page 13, item 3.3, consideration of a discussion regarding assessments for the 2014-15 school year. The department recommendation is to receive.
Ms. Smith, do I have a motion for this item?
So moved.
Do you have a second? Thank you. Ms. Smith, would you like to start the conversation?
Yes, thank you, Madam Chairman. Well, I just think that it's appropriate, and I know there's a lot of different things that are happening right now with regard to legal issues, but I'd like for us to just have some discussion about our 2014-15 school year, and I know there's been concern about whether we could lift maybe the suspension of temporarily to be able to do LEAP and iLEAP, and I would again like to bring that forward at the appropriate time in a motion. And just have some discussion again on possibly doing the LEAP and iLEAP, since it is nationally recognized standards, and I think it would give us some continuity in light of the fact that no matter what happens in the courts, there's probably going to be appeals and that kind of thing that we discussed last time. And I know your concerns about using LEAP and iLEAP again, Superintendent, but if we could in fact get approval from DOA to allow us to use that data resource contract, data director.
If I might, maybe I can just respond briefly, but I'll kick the conversation off. The concern has been expressed about where are we going to get test questions, or how are we going to assemble those test questions into forms. I don't think we have that problem. Whether it's LEAP or iLEAP questions from the past, whether it's PARC-generated questions for the future, we don't have a problem with that. The problem is in the following ways. Number one, printing them or publishing them online, delivering them to schools, training teachers to administer them, collecting them and having them sent back to Baton Rouge, scoring them, analyzing the scoring and issuing a public report. So whether we use LEAP or iLEAP questions from the past, whether we use future questions generated from some other means or PARC or whatever, that's not really a problem. It's all those other services that are the problem. And the issue then is the contract through which a vendor has historically done all of those things. Now, Ms. Smith is right. We might not get clarity from the courts immediately, but I think there is a chance that we might, because a court is meeting Monday. They met on their first case. Their first hearing was today. They had a status conference after that. They're meeting again Monday. And that Monday hearing is to determine whether or not there is immediate and irreparable harm done by the suspension of the contract. Now, I'm not the judge, obviously. I don't know whether he's going to give us clarity. But you gave us instructions at the last meeting that you can wait for that hearing, but you can't wait too long. By August 31st, you must have a plan in place as to how you're going to provide all those services. We totally agree with that. If the judge says, as Ms. Smith alludes to, I'm not giving you any clarity, it's going to be months, fine. We'll bring to you a plan to do it without that contract in place. If he says, no, I'm going to give you that contract, fine, we'll do it with that contract in place. So I think we're in a pretty good spot. We just need to wait for the hearing Monday, get clarity from the judge, or not clarity, and then we'll make a determination as to move forward, and we will abide by your August 31st directive.
Well, in that case, is there a chance that we are, depending on how the judge rules, I'm just trying to think ahead here, is there going to be a need possibly for a special meeting?
I don't believe so. You have never required a regulation to be passed in order to determine how a test shall be delivered. This is department procedure. This is a management activity. It's just an organizational question. Certainly happy to have a meeting if you'd like, but I don't think you would need to pass a rule. This is more just about the department doing its business. You've never had rules, or I should say you passed rules about how assessment is to be done. We've always just played by those rules.
Any other questions? Dr. Beebe.
Okay, Superintendent White, I certainly appreciate the explanation, but we're more or less in a position awaiting the court's decision, and again, I'm sure there will be an appeals process. So I don't know that it's in our best interest as a board to wait until a judge rules or the court issues a decision. So, I mean, do you have a plan as state superintendent?
Well, I would agree that, and I believe that's why the board gave me the directive that by August 31st, irrespective of what a judge says, we must have a plan in place. We have contingency plans and we have our standard plan. So we are all thought out. We are going to communicate with you as soon as there is some indication as to whether or not the courts are providing clarity, and we will advise as soon as we can. But it certainly will not be later than the 31st.
Well, I can appreciate what you're saying, but have you given any consideration to a moratorium on the assignment of letter grades to schools and to school systems? I mean, is that?
I don't believe we
know what you have,
yeah,
what you envision, but certainly, as a superintendent, and I met with faculty and staff just yesterday, and while we're moving forward, doing what we need to do, we need to. Our teachers are concerned with the lack of an assessment. So, I mean, the very least, we need to have some guidance and some understanding that, you will, depending on what the court says, that you will understand that we can't hold our people accountable under these conditions.
Well, that's what I mean, I know that you, as someone who sets high standards, I know that your teachers will be accountable, but I understand what you mean in terms of the precise measurement of accountability. Again, let me just state, if we don't have the services of psychometricians, testing experts, and if we don't have the services of a scoring organization that's not just, well, Mr. White scored his kids' tests, but a more formal scoring service, Dr. Beebe is right. It's going to be hard to have scores that are as precise and as comparable from one school to the next, such that you could score them for letter grades. On the other hand, it's very, there's some possibility, at least, that we will have those services. So that's why I say we have two different versions, and we will propose to you, Dr. Beebe, and the rest of the board, the appropriate accountability policy to coincide with the appropriate testing policy to make sure that we're not risk putting people in an unfair position by, let's just say we had a looser scoring system. Obviously, that would have implications for the letter grades and other accountability.
Any other comments? Ms. Hill?
So Superintendent White, if we, I know the board directed you, they approved and gave you 30 days to render a solution for Common Core and the issues. I do think we may need a special board meeting because I don't know I think as a board we should be very instrumental in that process because we need to know what will be your plan instead of coming in October because we'll be almost to the end of the first semester and the test will be administered in March. So my thoughts or whatever the rulings are that we should have a special board meeting to allow board members to be instrumental in that process because this is a very critical issue.
That's fair. And of course, if you as a board, that's your business. If you choose to have a meeting, then you should have a meeting. All I'm suggesting is that in response to what Ms. Smith said, we have in the past handled that as you've set up assessment policies. We do the operations of this. I believe that this is an operations question, which is how do you deliver the test questions to the classroom and how do you collect them, how do you score them. But I take your point. If you don't want to wait until October to hear formally again, of course we'll be here in Baton Rouge and welcome a meeting.
Any other board comments? Ms. Smith?
So, but whether we do LEAP or iLEAP or some other version of questions without a contract, either way, we're going to still have the issue of psychometrics that you're discussing. Who's going to collect? Who's going to score? We're going to have that no matter what.
If we do it without a vendor, yes. Yeah.
Okay.
Yeah.
So, and if you're going to use park-like questions or park questions without a contract, then we're not going to have a vendor.
It doesn't matter what questions we use. If you don't have in other words, we could use any questions. If we don't have a vendor, you're missing all those services. Yes, ma'am. And
so that's, and I'm really not trying to be difficult about this. I really am sincere in saying that I believe there's a lot of support among the school community to actually move forward with LEAP and iLEAP and be able to get the approval of obviously of Office of Contractual Review, but I really think that is a solution while we wait for the courts to decide. And I'm being very sincere about that. I'm not trying to be difficult. I'm sincere about it.
Well, I think I guarantee you this. We will be able to come back to you if the courts do not decide immediately with an immediate plan as to the questions, how we'll deliver them, how we'll collect them, how we'll score them, how we'll report on them. That you have my guarantee on that. I don't think that the questions themselves have much bearing on that. It's really a question of how do you do the operations no matter what questions you have. That's really the issue.
We have two comment cards, Lee Barrios and Deborah Moe.
Retired teacher, St. Tammany. So what's really strange to me is that we're talking about a matter of a week or two presenting this plan that obviously, I'm assuming you already have Superintendent White, these optional plans. why you won't simply tell this committee, who my understanding is that you work for them, now instead of waiting until the judgment and then here's the plan. I don't understand that, because that will factor into how everybody operates. The idea that a teacher can just, when you give her a test, change her modus operandi to suit the test, first of all, it's repugnant to me because it takes the high stakes aspect of it, but it just doesn't work that way. I also have a huge problem as a former teacher with the idea that a test that's presented even after the school year started, much less, 3 months before, that's not enough. And still to expect that test to be valid and reliable for high stakes purposes, which is the school performance scores, the teacher evaluation, and the student progression, even if the student is allowed to progress, if the student gets an F. I mean, I don't see how that, and I think you're looking at more lawsuits. I think it's been delayed already enough, and that you need to have a plan now so that people just know what's going to happen, regardless of what happens with the lawsuit. Certainly you're not going to be able to present a new test this year at this late date, so that's just, I don't understand you won't tell us what your optional plans are ahead of time now.
Thank you, Ms. Barrios. Ms. Moe.
Deborah Moe, President of Louisiana Association of Educators. I'm not going to say too much that's new from what I've already said before. I do believe that we need to know now what direction our teachers need to be going in. Superintendent White says that this is really a question of operations. I believe it's more than a question of operations. It's a question of the results and how the results will be used, who will end up being punished by the results. Without a vendor, if Superintendent White is correct, and we really won't get the kinds of results or accurate results as we would need, I really do believe that we need to have a moratorium on the accountability portion of the test this year. I am adamantly opposed to having any child, any teacher, any school district in Louisiana become collateral damage to a political battle between two governmental agencies. I would ask that you let us know as soon as it is absolutely humanly possible. I would prefer today exactly what the plans are, so that our teachers can begin the process of preparing the kids for that test. Or if there is no test, then they need to know that as well. We need to make sure that our kids are ready for whatever is coming their way. They're not political footballs. They're human lives. And we need to make sure that they are prepared for what is coming. Thank you.
Thank you, Ms. Moe. Any other comments? Ms. Smith, would you like to make a closing comment?
Is a motion in order?
We have the motion on the floor to receive.
Okay. Well, I'd like to make a substitute motion with the approval of the Division of Administration to allow us to use the 2013-14 assessment for the 2014-2015 year.
We have a motion and a second. Any comments?
I'd like to make a comment. Since we already have a timeline at the end of this month, I don't see the need to have this motion.
Any other comments? I'm sorry?
What's the question? I couldn't hear.
Would you repeat yourself, Ms. Moranti, a little louder?
I said since we already have a timeline to the end of this month, I don't see the need for this motion. We said we would make a decision at the end of the month as to what would be used for assessment. So why would we be making this motion now instead of waiting until the end of the month, which may be this motion?
If I may,
Dr. Beebe?
Dr. Moranti, at least it's a plan. As you heard, those who came to the table, they communicated the concern that we all feel we have a responsibility as a board, and then again, if what Superintendent White has offered as legitimate concerns, if the Office of Contractual Review is willing to allow the Data Recognition Corporation to do all those things, provide those services that Superintendent White alluded to earlier, at least we have a plan. Now, again, and you certainly, I know you recall the discussion at the last board meeting where the governor's representative said whatever the finding is, there will be an appeal. So I anticipate that this is going to go on for some time, and we need a plan if we're going to hold our students, our schools, and our districts accountable. Now, if we have a moratorium on accountability, that's another thing. But again, I think we need a definitive response today.
Just to summarize again, Monday there is a meeting with the judge. I would imagine the judge is acutely aware of the same issues that you are, which is that there needs to be a test in place for this year. We don't know what the judge will say. We don't know what the judge's ruling will be. I think it's just prudent to wait until then. I very much appreciate you giving me 13 days until after that time to produce a plan at the latest by August 31st. I would imagine it'll come sooner than then, because we'll know at least then whether or not we have the advantage of clarity. If we don't, Dr. Beebe, then we will produce a plan that goes forward without clarity, but it certainly will be no less clarity than we have sitting here today.
Mr. Garvey.
Madam Chair.
Mr. Lee.
Superintendent, do you have a problem with coming back to this board for approval of whatever your plan would be?
I think it depends the questions. There are some things like Dr. Beebe and Ms. Hill raised around accountability that I have to come back for approval. I have no problem coming back and presenting. I guess I can't think of anything off the top of my head that
your plan
would need. I think it's fine, I guess. Yeah.
Can we assume that that can be presented before the end of the month?
I think at a minimum you can assume that you can see it before the end of the month. Whether or not we can coordinate schedules and such, I think is not a question I want to speak to today. It's Labor Day weekend and all those things coming up. However, I do think it will be published in advance of then, and if you wish to hold a meeting and wish to vote on it, of course I will be there to present it. Does that get you what you? In other words, I'm fine. You've already required me to share it, so I will be sharing it prior to then.
I just think there's been so much confusion and there's so much politics and so much court action involved that there does need to be clarity, and it needs to be as soon as possible.
Agreed.
I do respect the Office of Superintendent and his interest in us not making a decision that might or might not would be what you would recommend until there's some indication from the court.
Yes, sir.
At least allowing a bit of time for that.
Yes, yes. But to be clear, I will publish a response, and if you wish to meet and vote on it prior to the 31st or after the 31st, of course I will.
I'm just
follow
thinking
along.
For those who would like a decision today,
yeah,
that there seems to be an interest in this board making a decision.
Fair point.
and not just the department.
Understood.
We have a proper motion on the floor. Would you reread the motion for us, please?
Yes, ma'am. Motion by Ms. Smith, seconded by Dr. Beebe, to approve, with the approval of the Division of Administration, approve the use of the 2013-2014 assessments. Do you want to specify LEAP and iLEAP? Or,
yes, that's fine.
The 2014 LEAP and iLEAP assessments for the 2014-2015 school year.
Any objection to the motion?
I object.
Roll call.
Yes, ma'am. Dr. Beebe?
Yes.
Dr. Beebe votes yes. Ms. Bophy?
No.
Ms. Bophy votes no. Mr. Garvey?
No.
Mr. Garvey votes no. Mr. Gio is not in attendance. Ms. Hill?
Yes.
Ms. Hill votes yes. Mr. Lee?
No.
Mr. Lee votes no. Dr. Moranti?
No.
Dr. Moranti votes no. Ms. Orange Jones?
No.
Ms. Orange Jones votes no. Mr. Romer is not in attendance. Ms. Smith?
Yes.
Ms. Smith votes yes. Ms. Bradford, do you care to vote?
Yes, and I vote no.
Okay, 1, 2, 3, 4, 5, 6, 7. The motion fails.
Now we we revert back to the original motion, which was to receive this report. We have a proper motion made and seconded. Is there any objection to the motion? Hearing none, the motion carries. Next item.
Next item is on page 15, item 5.1. Consideration of an update report on the Special Education Advisory Panel. The department recommendation is to receive.
So moved.
A second?
Second.
Thank you. Any comments or questions from the board? We have one comment card, Rana Ohalia. Rana. Otala. Excuse me.
Good evening. I'm a SEEB member, and we approved this, but I wanted to share with you some of issues that we want you to pay attention to or consider. We'd like to have a third party that could review IEP decisions, because we see there might be a conflict of interest if IEP is pushing, IEP teams, excluding parents, pushing for this when parents are not in favor of it, because for every diploma granted, there is 4 points. So if there is no third party to look at this decision, there might be a lot of, some room for abuse, not yet, some room for abuse, some room for problem. Florida state just passed a legislation saying that they need a third party to look at IEP decision concerning diploma, alternative diploma. I also want to see if we can have an option to opt out for parents.
Ronna, are you talking about this item, or are you talking about the future diploma
She's
item?
talking about later, a bulletin.
Did I mess it up?
Well, and it just, for this one in particular, is relative to the unofficial minutes of the SEEP meeting. So this is a 5.1 is for the board to receive the minutes of our meeting, which does indicate how that the board endorsed some of the policy that will be coming later.
Yeah,
so,
but I had some issues because the act says that you need guidance from BESE to proceed or to come
so
up
we'll
with a
have,
decision.
I don't know if you've had an opportunity to fill out a comment card for the item that comes later, but for the sake of the board members, it would probably help them to hear it in the context of that item. I was there, so I know what you're talking about, but
Yeah.
That's okay, thank you.
Thank you, Ms. Otalia.
What is it?
It's the
6.7.
Yeah, so fill out.
6.7, okay.
We have a motion on the floor. Do I hear any objections? So moved. The item carries. Next item.
Next item is on page 19, item 5.2, consideration of an update report on the Accountability Commission. The department recommendation is to receive.
So moved.
Second.
Any comments from the board in regards to this item? We have one comment card, Liberius. She stepped out. All right. Move forward. Any objection to the motion? Motion carries. Next item.
Next item is item 5.3, consideration of a report regarding the Early Childhood Care and Education Advisory Council, and the department recommendation is to receive, and that's on page 70.
So moved.
Second.
Thank you.
Members, this is a council that was created by a piece of legislation written by Senator Mike Walsworth that establishes the move that I talked about before of the child care licensing coming over to the department. Along with that was established an early childhood advisory council that will be kind of like our Accountability Commission, Special Education Advisory Panel. It will be the advisory body to you on these issues of special education policy. we are coming to you for approval of the selection process for members. And there are obviously things spelled out in the statute about who has to be there and so on. But BESE and the department together are putting out this process. We want it to be an open and transparent process, and we wanted to start that by having you approve this. As soon as you approve it, it would then go out to the public so that various people could apply to participate in it.
I have a question.
Ms. Hill?
So I'm looking at the council members and I'm looking at the appointing authority. So BESE has 1, 2, 3, 4. So how will we, as a board, we will have to nominate some individuals and then the board will approve? So for example, it says BESE will approve 2 representatives of the local education agency operating public funded early childhood programs other than Head Start. So we, as a board, would nominate those names? I mean, what is the process?
I think Ms. Cope can speak to it.
Yeah, so Ms. Hill, the board was given 6 appointments in the statute. So it's 4 categories, but you have 2 representatives in 2 of those categories. And so based on how we've done board appointments previously to like the Accountability Commission, we thought what we would do is put out an application with the department, and they'll take applications for the positions that the superintendent nominates. But then if folks want to self-nominate for other positions, we thought that makes sense to put out an application, and then we will forward those applications to the respective board member. So if somebody from Brobridge applies, we'll forward it to Ms. Beebe, and then Dr. Beebe can decide, I want to nominate this person. And like with the Accountability Commission, where we had a couple of people nominated for each position, the board will then get all of those individuals' names and their applications, and you all will get to decide at the, I think we're doing the October board meeting, vote on those individuals for your appointment. The superintendent will also present his nominations at that time, just for the board to understand and see.
Okay, well, I have a question. As BESE, why can't we do our own application process? Why do we have to do with LDOE? Why can't LDOE do their process, and as a board, we do our process?
We thought for efficiency, we would just use the same application so it wouldn't be confusing, because some people will qualify for multiple slots as well, so that way they can just do one application. And so the board will select its members at a board meeting on your own, separate from the superintendent. We just thought having one application would be more efficient, so it wasn't as confusing.
I don't want the issue of the LDOE recommending to the board who their thoughts are. So
they won't be. The applications, they'll just receive them on our behalf and then send them over to us, and we'll send out the applications that we receive to folks. You all are also more than welcome to nominate other people who don't fill out an application. So if there's somebody in your district that you would like to apply, we just would ask that for uniformity, every applicant or every nominee fill out an application. So you would just send them an application and say, please submit this, and let staff know that you're nominating them, and they'll come before the board. Does that make sense?
Yeah, I just want to make sure that they are not one and the same in regards to LDOE receiving the names, and they're making, I don't want.
We're just using one application form just to make it easy for applicants, but the department will run their process for their appointments, and we'll have our own process.
That's all I want to hear.
Okay.
Mr. Garvey?
Yes, I had a question for our staff. Did I hear you say that BESE will have 6 positions?
I believe it's 6.
Yes.
I was asking because I counted as 7, and I just wanted to double check.
I think it's 6.
Yes, 6.
Oh, you're right. I'm sorry. You're right. It's 7. One of the nominations is chosen from a list of persons nominated by the Head Start Association. I'm sorry.
Thank you.
Any other comments?
Okay.
Madam Chair,
Yes, Mr. Lee?
concerns me that I would think a majority of the children are going to be in public schools, but there are only 2 representatives from public schools on this list of 17. That sounds like it's underrepresented to me.
The council members were lined out in statute, so we don't actually have any control over.
I'm sorry, I'm not understanding.
The statute that created this council specifies who is on it in terms of representatives, so we don't have any control over the types of individuals on this council.
I don't see that designated over here in the legislation.
What do you mean?
I don't see it saying you can only have 2 from public school systems.
I think that the statute pretty clearly spells out who's supposed to be on it. Here's I think the issue, and this is something that we're all trying to get comfortable with myself. Most of these kids are 0, 1, 2, 3 years old, not 4 and 5. So in other words, most of these kids are actually not in public schools.
Do you know what percentage are 4 and 5?
Well, in terms of the percentage of kids in public schools.
No,
Well, let me get there. So you got 17,000 in LA4. Now you've got about, between birth to 4, total 200,000 kids of those age levels. Now, not all of them are in child care and Head Starts, obviously, but I think it's a pretty significant minority, birth to 4, that are in a public school setting. And that's not to say the law was written right, but it is to say that this is the law. And Aaron, you can correct me if I'm wrong on that. I believe these are spelled out pretty specifically in the law. But I think that's why. I think that's why it was written that way.
2 out of 17 sounds like underrepresentation to me. And I don't believe the law says there can only be 2 out of 17.
Well, it might not say you can only have 2 out of 17, but I believe, Aaron, it spells out 1 of this type, 1 of this type, 1 of that type. I think that's the way it reads.
That's 2. Any other questions, comments from the board?
Yes, we don't have a timeline here, so what's the process and when the application will go out, when they apply?
Yes.
I mean, we don't have any of that.
Go ahead.
No, go ahead.
So as we delineate, we're going to put out the application. We're on schedule to put it out this week. Applications will be due by, I believe, August 29th. And then we will bring the nominations to the October board meeting, which we've lined out in the exec rec.
Okay. Any other questions?
The law does say two district representatives. Okay, that's what the law says.
It says what?
It says two district representatives, right? Yeah, that's what the law said.
We have a motion on the floor to receive. Any objections to the motion? Motion carries. Next item.
Next item is on page 73. Item 6.1, consideration of revisions to Bulletin 132, Louisiana Course Choice Program, as required by actions of the 2014 regular legislative session. The department recommendation is to approve as notice of intent.
So moved. Thank you. Do I have a second? Second. Thank you. Any comments or questions?
Members, I would just say that this is another one of a series of laws that was passed. This will just be reflected in the bulletin. We worked very hard with Senator Blade Morrish, with the School Board Association, to bring this law into line. You then put this law into the MFP. In other words, they were being drafted at the same time, and as a result, enrollment in course choice funded by the supplemental course allocation in the MFP is really through the roof. But this is a direct statute to regulation copy.
Questions from members of the board? Comment cards? Hearing none. Any objection to the motion? Motion carries. Next item.
Next item is on page 81, consideration of revisions to Bulletin 741, Louisiana Handbook for School Administrators, as required by actions of the 2014 regular legislative session. The recommendation is to approve as notice of intent.
Thank you. Comments or questions from the board? Yes.
Members, this is a very similar situation. This is, as you know, our biggest bulletin, Bulletin 741, infamous. It has to be amended anytime a set of academic policy laws are amended in the legislature or created. So what you're seeing here is a kind of an amalgamation of different laws all wrapped into this bulletin. The most significant of them is the career diploma law. As you know, the career diploma implementation is really taking off, so that's great news, but we need to go back and amend the bulletin to align with those laws, and we are just taking copies of the law and putting them into the bulletins.
Questions or comments? Any objection to the motion? Motion carries. Next item.
Next item is on page 104, item 6.3, consideration of revisions to non-public bulletin 741, Louisiana Handbook for Non-Public School Administrators, as required by actions of the 2014 regular legislative session. The department recommendation is approved as notice of intent.
So move.
Thank you.
This, Madam Chairman, is the exact same situation. This is just the private school version of that bulletin.
Questions, comments? Any objections? Motion carries. Next item.
Next item is on page 123, item 6.4, consideration of revisions to Bulletin 119, Louisiana School Transportation Specifications and Procedures as required by actions of the 2014 regular legislative session. The department recommendation is to approve as notice of intent.
So moved. Thank you. Do I have a second? Thank you. Ms. Ernst-Jones.
Does this address the, okay.
I thought we were going to get away without it. That's somebody asking. This does not address the now very well-known and deplored school bus bill. Right. These are different school bus bills. I'm happy to report, however, that the Attorney General did say in a ruling last week that that bill has no date of impact. Thus, its date of start can be delayed until we get it rectified in next legislative session.
Right.
These are much less consequential bills that address an issue that we have debated before, which is the requisite age of a school bus for use in the school systems. Again, just copying the law and putting it into the bulletin.
I just have a comment as it relates to 2509.
Dr. Beebe?
I'm sorry.
That's okay.
Okay. You know, who's the bus patrol, to say 60 consecutive days? I mean, certainly, I would think our people would be honest, but I mean, I think sometimes our legislators need to sit and go through the in-services where someone clarifies the legislation, the passage of the legislation, and the unintended consequences.
Because you may have a bus that you have to take out of commission for one day in order to satisfy the terms of the law.
Yeah. And who's to say I mean, who's the bus?
Yes, understood. Yeah.
Any other questions or comments? Any objections to the motion? Hearing none, motion carries. Next item.
Next item is item 6.5 on page 127. Consideration of revisions to Bulletin 1706, Regulations for Implementation of the Children with Exceptionalities Act, as required by actions of the 2014 regular legislative session. The recommendation is to approve as notice of intent.
Do you have a motion? Thank you. Do you have a second?
Second.
Thank you. Any comments or questions on the motion?
Similar, this is a law that's being placed in a bulletin. This regards choice initiatives for students with disabilities. There are technical changes to that. Well, I mean, I'd call them substantive, but not major changes to that piece of legislation.
Ms. Italia, is a public comment?
I'm not sure what BESE can do about this, but it lists certain exceptionalities where kids can qualify for this option, and that does not include deaf and hard of hearing kids, does not include visually impaired kids, and does not include deaf and blind kids. And this is concerning because we know about a lot of parents place their kids in private schools because they don't think public schools meet the needs of their kids, and this should be a great option for them to help with the cost. So I just thought I'll bring it to your attention. I know it's legislative and might need to go back to legislation to correct it, but it's concerning that the author of the bill only included certain disability and did not include the 13 disability under IDA. Thank you.
Thank you. Any questions or comments? Hearing none. Any objection to the motion? Motion carries. Next item.
Next item is on page 132. Consideration of revisions to Bulletin 118, statewide assessment standards and practices related to test security. The department recommendation is to approve as notice of intent.
Do I have a motion?
So moved.
Thank you. Do I have a second? Thank you. Mr. Superintendent.
Thank you. Members, these are changes to security policy related to testing. They've been debated now at the Superintendent's Advisory Council for a year, and I believe we've come to a good point of resolution. Mainly, they are common sense changes such as ensuring that a student, when there is a cell phone that's been found, that the test results are avoided, or attempting to minimize the number of days that a test booklet sits on the site where the test is administered.
Comments, questions? We had one comment card by Ms. Barrios, and that she is not here. She did oppose the motion. Any more comments or questions? Hearing none. Any opposition to the motion? Motion carries. Next item.
Next item is on page 140. Item 6.7, consideration of policy recommendations relative to the assessment, promotion, and graduation of students receiving special education services. And we have 5 bulletins that are being revised for this item. And the first bulletin is Bulletin 1530, Louisiana's IEP Handbook for Students with Exceptionalities, and the department recommendation is approved as notice of intent.
I think we'll take these for discussion one by one so that we can hear comments and have questions from the board. Any questions from the board?
I do.
We
need a motion. Oh, sorry.
So,
we need a motion.
Since the
We need a motion.
Well, I'll make a motion, but I have to preface it with some information if that's okay.
Oh, okay.
So since the packets were made available, we've had our SEAT meeting and we're able to get some feedback on this from our special ed advisory panel. And so there's some revisions that have been made since the packets went live, and those are being passed out to you. So I would like to move the board approve the revisions to Bulletin 1530, Louisiana's IEP Handbook for Students with Exceptionalities, as amended. And you're getting the amendments right now, and we can get the department to help us understand what some of these amendments are if people have questions about them. But this is based on feedback that we were able to receive since our packets went live.
Okay, feedback from the special ed?
Yes.
Excuse Chairwoman.
I need a second to the
Madam
motion.
Chairman or whatever.
Thank you. Ms.
I have
Smith.
a
Second.
No, I don't second this. I have a concern.
Okay.
I second it.
Thank you. We have Ms. Hill.
Okay. These are the recommendations from the Special Education Advisory Council. These are some of the changes that you guys decided in your meeting.
So we had Mr. Fleming's here, and so we can talk him through. At our special ed advisory panel meeting, he presented to the department certain revisions, and this reflects those revisions there, which weren't in your packet because I think that went live before we were able to have our meeting or shortly after.
So when was the meeting? When did the meeting take place?
Last Monday. Was that the 4th? Yes. Yeah, we wanted to meet in time for the panel to be able to consider. There's a lot of bulletin changes here as a result of the new legislation, Act 833, and so we wanted to have the panel to have an opportunity to consider those and provide feedback before it came to the board. At the meeting, the panel did endorse the changes.
Okay, I guess my concern is because I've read through the packet in regards to what I have, and to give me this right now to read this, because this is very critical to me when it comes to students with exceptionality, and then to ask me to approve this now without having the proper time to read this information and digest it. So I think this is the issue that I have with the board, is that we get information in such a late time, and then you ask us to approve, and it's like, what the heck are we?
Well, maybe I can explain, and I apologize. Maybe I can explain. This law was passed, as you know, signed into law in middle or late June. It is a very large piece of legislation, and it connects local school district activities with state policy, with federal law, and that's the key piece. IDEA and ESEA are very closely connected to this. Thus, our friends in the advocacy community, and we had to talk to the federal government on multiple occasions in order to get clarity as to how this corresponds with their laws. We then brought back a solution to the Special Education Advisory Panel. They worked it through, and then after that there was a lot of fallout, as you know, comes from those kinds of meetings. So we had a bunch of discussions after that. So it was, unfortunately, this is bumped up against the start of the school year because we can't wait until October to get this passed. So you have my apologies. I think it was just necessary in this case, kind of one of those times.
Well,
Ms. Hill, yes, I'm
this is a
sorry.
very sensitive issue when you're dealing with that population of students. And so for us to rush it through,
Yeah.
I have an issue with that. And so
I-
that's
I-
my concern, because
Yep.
I just have an issue with that. So this is what I do. So I don't know how we're going to rectify the problem.
Well,
but-
here's part of the problem. The part of the problem is that the law calls for an immediate evaluation within 30 days of the start of the school year of such students' situations. So in other words, if you don't get it passed now, then you won't have the opportunity to evaluate those kids' situations because the 30 days will have passed, and that's why you're getting the urgency from us. Madam Chairman, would it be appropriate for me to walk through this document?
I would think the changes that are from what we had in our packet, to highlight those would probably be helpful
Yeah.
to all of us.
Yeah, okay, all right.
Let me ask a question also. Not only would I like to hear an explanation of the differences between what was sent to us and what's just been handed to us, but also if you agree with today's recommendation or not.
I do, and let me just describe the essence of, this is going to get a little cumbersome, so I apologize for sounding so wonky. Here's the question. The question is, which students are eligible for what? You have a bill or a law now that says that students with disabilities, some of them, may be placed onto an alternate track, essentially. They may demonstrate they're ready to graduate through an alternate means. That's the core of it. The question then comes up, well, what about for students who have the most significant disabilities? Or, to get to your point, Ms. Hill, the most vulnerable kids are Law 1 students. Those students are not pursuing the traditional academic standards. And so there's a question came up as to how are they included in here. What you got in your packets was a reflection of the federal laws, which say that such students cannot receive a standard diploma, and that if they do receive such a diploma, it cannot count for accountability purposes. What you are receiving here that is different, and Ms. Hill, I hope that this will give you a summary or synopsis of the situation, is that we actually are saying they can receive a diploma, that students who are not pursuing the traditional standards can receive a diploma. That diploma, per federal law, cannot count for accountability, however. Now, I would encourage the board to also work with the department on finding a way to count those kids in the accountability system, which is still a missing piece of our accountability system. Absent that, our accountability system is kind of blind to those kids, and that's really inappropriate and not fair. Not just not fair to schools, not fair to those kids. But what you see here, really, the distinction is between what was before, which was essentially they won't receive a diploma and they won't get counted in accountability, to more they can receive a diploma. It can't count for federal policy reasons under accountability. But our position is we've got to find a way to include Law 1 kids in our accountability system. And that is effectively the shift that you see here.
Superintendent White, if I may.
Yes.
So how do they address this in those states where they do hold special ed students accountable?
Well, I think there's a dispute about this, and I think there probably will be testimony about this. The feds say that there are no states where Law 1 students graduate, are given a diploma, and that counts for accountability. And I understand why. Because ESEA insists that those students who graduate all graduate achieving the same standards. I think some of our experts might disagree with that. You know, that is what it is. That's what the feds have told us. However, I don't think that there is a state that has found a way to count the achievement of Law 1 kids in their accountability system in a standardized way. I think we can lead the way in doing that. It's a very badly missing piece of our accountability system, and it needs to happen, or else you're basically saying to the schools, you're not accountable, you can't graduate these kids, and you're not thus accountable for actually them achieving meaningful learning targets. That's a problem. I think we can find a way to do it. We were already engaged in discussions with some people who do this work day to day, and I think we can find a way.
So like in Arkansas and Texas, those students are excluded from the accountability?
The feds would say yes. Yes. Now I know that Sean and others who have studied this issue a lot would say no. Maybe that they've found a different way. But the feds would say yes. That state is not counting Law 1 students when they graduate toward their cohort graduation rate.
Okay. So if we're hearing conflicting positions, I think that we should maybe defer until we can communicate with authorities and officials in other states.
Well, we did a conference call. We did a conference call with the federal government, and they have confirmed their reading of it. I just wanted you to know there might be those who contradict what I say about the feds. The feds have given us very clear guidance on this. However, one, we have adjusted our guidance. We believe we should award a diploma. And two, we also think we need to find a way to include these students in our accountability system.
Any other questions? We have several comment cards. Yes, Ms. Smith.
Was this was the John Schroeder bill?
Yes.
Okay.
Yeah.
So the intent of the legislation, I guess if someone else comes to the table, I guess they can talk to it, since I know Representative Schroeder had surgery and couldn't be here, but the intent was that students are allowed to get a diploma if, in fact, they meet certain guidelines and requirements.
If they demonstrate proficiency in a way as determined by their IEP team.
Okay.
Yeah.
If they complete their IEP and that's determining. So the intent was that they're allowed to get a diploma. Was it discussed during the session about the concern with the Fed saying they can't be counted in the accountability measure?
I certainly think it came up. I think the debate that came up, and I was a part of this, and Sean was a part of this, and others, was, is this a bill to modify standards and curriculum? Is it a bill to modify assessment, or is it both? Under this law, kids take the end of course tests in high school, but they aren't necessarily required to achieve the benchmarks that students historically have been required to graduate. That is what can be modified, is the assessment as to whether or not they can qualify. They don't have to pass end of course tests if they're put on this path. That's a different thing, however, from modifying, say, the content of the course or the standards themselves, which we are saying under our reading of the law and under our reading of the SEA cannot be modified in order for the kid to achieve. It is the assessment that is to be modified.
So is it and I really did not get to listen to much of the discussion on this particular piece of legislation, but is it the intent, would we be trying to work toward a measure to be able to, I guess say, not shoot ourselves in the foot if we've got kids that are actually able to receive a diploma and then be counted in some measure in a positive way in our accountability system? I would think that would be what we would want to do.
Yes.
So what will we have to do to convince the feds that that's a good idea?
Well, I think they're okay with that concept because I think they know it's a problem in their system. I think they're aware it's a problem that Law 1 or whatever other state's equivalent it is not counted in their accountability system in a meaningful way. My sense is most states are willing to kind of accept it. I know there was some debate between some of the members on the call and the federal government about whether or not other states actually were counting those kids. Then there was a back and forth debate. The feds say no, no, no. I think here in the end is the point. We can find a way to say these students have achieved meaningful targets even if their disability may prevent them from achieving their traditional standards. We can do that. And we've got fantastic work like going on in Bossier at BESE around students with significant disabilities who are achieving meaningful applied and vocational benchmarks. There's no reason why that couldn't be counted in our accountability system. We just need to find a way to do it.
Will it take legislation, or is there a way that we can incorporate what Representative Schroeder has in place through rulemaking?
I think we could do it at BESE. I think
Okay.
the accountability system is BESE's domain. I think we could do it at BESE. Yeah.
I have a question for Super, since we're at
Yes.
For graduation, requirements for graduation, Section D, it talks about students with disabilities and those who have significant cognitive disabilities. And it states, and I need some clarity on there, it states that if a student is not on a regular academic route, that they would not be able to receive a regular diploma. So give me some, because when you look at some of the students with disabilities, some of them are not on a regular diploma route.
Well,
Let's
it
keep that
says
in
that it doesn't say that they won't be able to achieve a diploma. They will be able to achieve a diploma. It says only diplomas earned by students who have pursued the regular academic state standards and who have earned all state-required Carnegie credits, meaning that students with disabilities who are pursuing the regular standards, which is the vast majority, their diploma is to be counted in the accountability system. And that is the federal law coming in there. Now, here's the issue. We're also saying, and this is the first time we've said this, that a student who's not pursuing the traditional standards could receive a diploma. We're just saying, per the federal guidance, that that diploma cannot be counted as part of the cohort graduation rate in the accountability system. But third, we're saying we've got to find a way to count those kids in our accountability system, or else we effectively have said we're not accountable for having them learn. So what percentage of kids are we talking about? We're talking about roughly 1% of the students in the state fit that category.
Mr. Garvey.
Yeah, Superintendent White, I want to double check to see if I understood you correctly. Did you say that students who are not pursuing the, maybe you said regular standards, can get a diploma, but that diploma will not count in the accountability system?
That's correct.
Okay. Are any of those students Lot 2 students or previously Lot 2 students?
No.
So all Lot 2 students or previously Lot 2 students will be seeking or trying to achieve the same standard as the other students?
Yes, sir. And that's effectively the old Lot 2 category. The definition is that there is an alternate assessment, but the curriculum and the standards, while the teaching may be different, the curriculum and the standards remain constant for those students. So those students would be a perfect example of, under this law, they may take the regular coursework, but that assessment, to the dialogue I was having with Ms. Smith, would look different. That assessment might not be the Algebra 1 end of course test. And this law allows the IEP team to say, let's find a different way of measuring that kid's learning to allow that child to graduate. Because what we're seeing now, and maybe I should have said this at the outset, by the time you get to high school, nearly half, not quite half, of all students with disabilities are Lot 2. Well, those kids, a lot of them are getting caught up in the end of course test net that's not allowing them to graduate. It's not that they're not doing the coursework, it's not that they're not pursuing the standards, it's that they're getting caught up in the test. And this seeks to change that.
Any other questions or comments from board members? We have comments from cards from the audience. Bryn Millet. Bryn Millet. It looks like Bryn. Brian. Edward Breeden. Ms. Otalia, if you'll come down. Liz Gary. And Rebecca Ellis. Please be sure and tell us who you are and turn your mics on.
It's on.
Thank you. My name is Edward Breeden, and I have concerns about why I support Bulletin 1530. My concern is about pushing kids out of school before the age of 22. Let me tell you my experience I have. I have a daughter at the Louisiana School for the Deaf, and the IEP team attempted to push her out of school at 18 until I said no. The parent is only one member
On that team.
one member of the IEP team. Currently, there is no opt-out option in this bulletin. I think it needed to be added. Thank you so much.
Thank you for your comments.
May I just provide some context? This is, I think, a very important piece of this to understand, and this was debated, to Ms. Smith's point, during the session. I didn't win that.
But I think maybe if we have guidelines to where those individuals on the IEP team has a checklist to ensure that the parents understand what their rights are. Because I totally agree with the parent. I sit in IEP meetings, and most of the times those parents come in there, they're not aware. They get that booklet. How many of them read the booklet? Let's be honest. So they're really going by what the experts are, which are those people that's on the IEP team. So I think if we have to hold the team more accountable to ensure that the parents are more educated in regards to what the needs are for their child. I mean, I'm just from experience. So is there a way that we can put it in a guideline what districts will have to follow before they make their final decision?
Especially right before they reach that age, they're identified because out of
Yeah. So we're talking about perhaps there being a notice of these specific legalities. You should know that the implementation of this law is going to look a lot less like a BESE level policy making and much more like academic and developmental guidance to the practitioners and to parents. And so that's going to, I know that the Developmental Disabilities Council has already started that work. We're going to be doing a lot of that work. So we'll keep you updated. Yeah.
I'd like to be a part of that process if we do this, if we decide to move forward. Because a prior notice is mandated by the state that we have to send out a prior notice to the parents, informing them of the IEP meeting in regards to their child exceptionality. But once they get there, they're calm. They will attend, but once they get there, they really don't know.
Yeah, agree.
First, I want to say, as a SEEP member, this is not what we voted on. This is the first time I see it, so we can't say that SEEP approved this.
This right here?
Yes. I just seen this, and I have some concerns. Number two, Superintendent White has been talking to a lot of advocates, but he's been talking to one side of the advocacy group and not the other. I appreciate in any discussion that we talk about anything that concerns the kids, we need to listen to both sides of the story because there is a lot of input coming from people who oppose and people who support. We want to talk about FAPE, denying FAPE by graduating kids early. This could be non-compliance. We've been talking to the federal level. And do we know that there is $292 million at stake for any violation that comes with this law? Washington State lost $40 million, and a lot of students lost services, and a lot of teachers got fired because there is no money. So if we want to proceed with this, the Act asks for BESE and the department and SEEP guidance to implement and put procedures and policies. If we keep focusing that any violation of federal law that comes out of the implementation of this law could cost us $292 million. We need to pay attention. And I also want to bring up some stuff. Monitoring is an issue. We need to look for a third-party person to come and figure out, is the parent right or is the IEP team right? We cannot put in place a policy that demand parents to go to court if this doesn't work with them. We cannot. This is too much hardship on parents who are already not educated, already can't speak the language, already overwhelmed, already busy. You have not seen so many parents against this act because everybody works. Nobody is a paid advocate. There is so many out there, they oppose this and they don't want their rights taken away from them, but they cannot show up at every meeting saying we are against this. Florida allowed in their legislation a third party to come in and monitor these decisions because it cannot be made by the IEP team who's paid by the district who gets points. So they look better. We don't want more points. They brought up Texas. Texas has higher graduation rate, but it's the lowest performing school in the nation. Nobody brought up this information to discussion when they pushed for this bill. It came out by the federal government. No national organization came out and supported this bill. I'm sorry. there was about 28 to 29 national organizations that came, said no for this thing because it's too much power for the IEP team, it's too much rights taken away from parents. We want kids to be successful, but not by granting a diploma. We want to teach the kids. Why don't we start early enough, give supplementary aids and services, give whatever the kids need, and get those kids to be able to earn a diploma. We're going to de-appreciate the value of diploma for all other kids with disability who work so hard to earn it. There's so many things we want to discuss, but I really appreciate if Superintendent include both sides of the aisle when you're discussing any changes. We have not seen this. We cannot say that.
Let's talk about just a couple of things. Okay. Number one, you know that I'm sympathetic to a lot of your perspectives on this question, and I would say that during the debate, we were trying to walk a line between the two perspectives and find the right middle ground, because I do think that the diploma was too rigid before. Whether it's gone too far to the other side has yet to be proven. Secondly, I think in my conversations with the legislature, they don't tell me they want to get this wrong. I think they want to get this right.
Yes.
It is incredibly complicated. I'm sure that they are open to us coming back and saying, hey, look, Representative Schroeder, this went right. We need a little change here. I'm sure they're open to that. So here's what I would suggest. I think we all need to get together, try to make this as good as we possibly can, try to be open and honest where there are problems, and try to bring it back to Representative Schroeder and his colleagues next session if there are problems and say, let's change it. I will say this, what the advantages are or not, I don't know, but LaTeach really showed up, and they persuaded the legislature in a major way that things need to change. You can call that for what it is. I think if there's an alternate perspective, that needs to be voiced in larger numbers too.
It will come in, and we try to get national to help us show you guys what's going on and why there is a risk. We cannot afford to lose $292 million.
But Superintendent, I just want to point out to you, the leader of LaTeach is a state-paid employee. And I'm just a parent that works. And it's really upsetting that I have to take a day off and I find out about this stuff after the fact, and I'm a parent.
Yeah, no, I understand. We don't need to belabor it, but remember, in House Education, this went out without an objection. In Senate Ed, it went out without an objection. It passed off the entire House floor without a single nay vote on it. Now, do I think every one of those votes fully understood the issues of FAPE access you're talking about? No. But it's our responsibility to educate them. And whatever side I was on at a given point, there were certain issues on which I was sitting up there alone. So we've got to, if we want to represent all perspectives, I hate to say it, but we've got to find a way to get voices there. At the same time, I have great respect for what Sean and LaTeach did. They brought an important issue to the table. Let's try to make it work. If there are problems with it, let's come back and change it.
I agree.
Thank you
for your comments.
Just really quickly. We have a live example in Louisiana that shows us how IEP team decisions without the parents being involved can destroy our kids. Louisiana School of the Deaf, the lowest performing school in Louisiana. Only people making decisions, IEP team, because parents sign that the department, whatever, the school decides everything. 72% of their population is in Law 1. Most of kids with hearing impairment do not have cognitive issues. There is a big problem going on, and this is example of what could happen if this was a statewide issue. That school has all accommodation, has all professionals, all money funneling into that school to promote kids' success. They're not succeeding. We have 2 or 3 students graduate with a diploma every year out of hundreds of students. This is what happens when IEP team take the leads. Parents need education, parents need training, and that has to be part of the implementation.
Thank you for your comments. We appreciate it. Thank you. Liz?
Hi, I'm Liz Gary from St. Tammany Parish, and I'm a parent. One thing I want y'all to remember is that one of the reasons this all got started is because when the scores came out, we only had 33% of our individuals with disabilities graduating with diplomas in comparison to 60, 70, 80% throughout other states. We failed. We were at this bottom 2 as far as graduating students with disabilities. So therefore, parents went, as well as the council, went and started searching for answers to see what exactly was wrong. I have a hard time believing that our individuals with disabilities are less intelligent than other states. It was clear that it was policies, not our individuals, that were driving the problem with the numbers. And so that's why, as parents, we felt it was important to give our kids the same opportunities that other states were getting to get our kids where they needed to be, which is one of the reasons reasons, and one of the largest reasons why this bill. We did bring this bill to Representative Schroeder, who agreed to bring it forth, and it was unanimous in the House, and it was unanimous in the Senate, as well as a large amount of co-authors signing on to this bill. This is why the bill is here, because it's important to our families and our kids to have opportunities. We clearly understand the importance of a diploma. I know that when you go in there and say, do you have a diploma, these kids are not going to get jobs if they don't have a diploma. A certificate of achievement does not get them a job. And so therefore, it's very important, and that's why this bill, and I appreciate the time, I appreciate the fact that the department has worked with us, I appreciate the fact that we are now collaborating with so many different groups of people, not just parents by themselves trying to get people to hear us. It's now a collaboration, and we greatly appreciate it. Thank you.
Thank you. Ms. Ellis.
Hi, my name is Rebecca Ellis, and I'm also from St. Tammany Parish. Some of you were here last October when I shared some thoughts with you that ultimately traveled to Diane Ravitch's blog and also to the Washington Post. But it was entitled, Is Anybody Listening? And it was partly myself airing some frustrations that I've seen on an individual and systemic level, where I felt as though our policymakers weren't listening when it came to improving outcomes for students with disabilities. And I'm happy to say that this session we felt as though our policymakers listened. And today I feel as though the department is listening, and I hope at the end of this to be able to say that BESE is also listening. So in sum, I'm just here to say thank you for listening and look forward to continue to collaborate with you guys.
Thank you. Our next speakers are April Dunn, Dr. Lauren Mayfield, Ashley McReynolds, and Kavira Johnson. Excuse me. You'll come down. Sure. Yes, that'd be great. In fact, just Sean, come on down. And you don't have to give him your spot. He'll just be in line.
Good afternoon. I'm Sean Fleming. I'm the Deputy Director of the Louisiana Developmental Disabilities Council. We have had some conversations. I guess, you know, I'd want to start with thanking the department. They have made, I gave them a number of changes, you know, on behalf of the council that aligns these policies with the bill, basically. It puts the language that was in the bill in, and they put all those in. I appreciate that. There was one word choice that was an error. D was the only part that was not in the bill, and I guess I'd like to speak to it because it was put on the table of how the federal government and ESEA, that is the Elementary and Secondary Education Act, does and does not play into this at all. It is true that ESEA has requirements for diplomas for district and state accountability purposes. However, I had the pleasure of being on the phone with Michael Uden and Deborah Delisle and a couple of other members of the U.S. Department of Ed this morning with Representative Schroeder, and the question that was posed to them was this: where in ESEA does it require that those standards and those proficiency levels for the district and state accountability need to be used, must be used by a state, not only for kids with disabilities, but for any student, for determinations of promotion or graduation? And they confirmed it is not. And that is significant, because what part of the confusion, I believe, in their letters that were written, they sent one May 21st, I believe, to Superintendent White, and another one on July 2nd. It indicates that they were perceiving a new interplay with those between ESEA and determinations of promotion and graduation. And they're for separate purposes. Those benchmarks, those standards, those assessments that are used for the state accountability, for the district accountability, are on the aggregate. So we can see in general how people are performing on those academic standards. But when you get to an individualized student decision about whether that student should be moved to the next grade level, or whether the people working with that student have determined that student has done what is necessary to graduate, those things do not play in at all. In fact, about half the states don't have any requirement related to those assessments required under ESEA for graduation. That's the easiest way to see that. So it's clear that when the US DOE wrote some of these things, they were confusing things that have not been interplayed. And I'm not a lawyer, so, Mr. Garvin, maybe you can help me understand how a few attorneys explained it to me this way, is when you have a general law, say as ESEA, that applies to all people, but then you have a law related to the individual rights, as IDEA, Individuals with Disabilities Education Act, does. The individual requirements supersede those general requirements. And that seems to have been misplaced in, I guess, a few states, and in Louisiana in particular, as we have developed over time our promotion and graduation requirements that were not used in other states. So when it came to our attention and we looked at all the policies, it's clear that other states, they allow much more individualized approaches and pathways to graduation. And that language was put into Act 833, and as I read D, it's just clarifying, I guess, for the benefit of the federal government, which I think is interesting and good, saying, where ESEA requires us to have these state and district accountability measures, and where diplomas fall into that, only those diplomas that are based on those Carnegie units for students who are pursuing the standard academic state standards will be counted. It does not speak to denying kids, I guess, diplomas. Looking at it, I would wonder whether you would want to take out that first regular. Superintendent, I'm just looking at, there aren't any regular academic standards. There's only one set of academic standards. There are extended standards that students on Law 1 take. But that's a minor thing. I'm not that caught up in it. I appreciate the department's continued working. I think this is a very complex issue. I think for educators, I'll finish just a second, please. It is causing a lot of, angst just with the shift. We have done a severe shift, and it will cause a severe shift in thinking how kids are educated and what they're required to do. So I'll answer any questions. I appreciate your time. Thank you very much.
Thank you for your comments. Dr. Mayfield.
Maureen Mayfield, President of the Louisiana Association of Special Education Administrators. I wanted to echo what Sean said. I appreciate that the department is now working with us in trying to fine-tune the rules that are before you. I do have a problem with paragraph D, and it's based upon what Sean said. I think we have to be very clear, and I believe that on the call with the federal government, US DOE this morning, they made it clear that ESEA is concerning accountability. It has nothing to do with promotion and graduation. Act 833 is a bill about promotion and graduation. I believe this whole paragraph should be removed from this guidance. If accountability needs to be addressed, which I'm sure it does, I think that's another fight for another day, and it needs to be somewhere else. My concern, even in talking with Superintendent White's staff prior to this meeting, what I'm hearing them say versus what Sean's hearing them say, and our interpretation of the language, it's not exact. And I'm very concerned if we're saying that the only diplomas that can count in accountability are those where the children have the same level of achievement expected of all students. By definition, that would knock out any children that come under Act 833 and put on an alternate pathway would be taken out of accountability. Because under the Act, we're saying they have not been able to meet the normal standards and benchmarks. The IEP team can now set those standards for them. So I have a real problem with that. And I just want to echo what Sean said about that misalignment between ESEA and IDEA, and point you to the recent congressional report on that misalignment. I think it's very good guidance for all of us. I would just like to see the accountability piece taken out of this guidance. The only other thing I wanted to mention is that I really appreciate the comments of the parents, and I want you to know that as we have spoken with the special education directors and supervisors in the state, one of the things we put on our draft form that we gave them as initial guidance was a statement to be given and signed by the parents explaining if your child leaves prior to 22 with a diploma, that is the termination of FAPE. So we are not trying to do that. I cannot imagine a special ed director who would encourage that. The opposite is true. We've been saying talk to those parents if we have, say, a 17-year-old that was about to drop out because he only has half the Carnegie units needed for graduation, and say, look, if you will stay till 22, we think now under the Act we can get you there. You can get those 23 Carnegie units and you can graduate. So I appreciate the comments of the parents. Please know that the directors appreciate those things. We're all working together now for the first time, I think, for our students with disabilities. Thank you.
Thank you for your comments. Ms. McGrillis.
Good afternoon. I'm not going to repeat what's already been said, but I do want others to realize that I too am a parent of a child with a disability, developmental disability, who too, along with other parents, when the USDOE put out the graduation reports, questioned why were we second from the bottom. And when we got together with Lucia and other advocates, it wasn't, like Liz said earlier, it wasn't that our students weren't as smart or weren't as capable, it was the policies. And so that was the intent of House Bill 1015, which is now Act 833. And I too agree and thank the department, Bridget, Devlin, for working collaboratively to ensure that the policy language in front of you today is not just the intent of the bill, but really the spirit of the bill. So I do want to thank them personally for that, and hope that we can continue working collaboratively together. And I echo what Superintendent White said, is this is the act, this is the law, and while we are going to have people on both sides, it's best if we can all work together to make sure that it's implemented properly and with respect and due diligence for each student that is determined that this is the best path for them to graduate high school with a meaningful high school diploma.
Thank you so much. Jeanette Dunn, Deborah Sham, Flavia Eldridge, Donna Reno.
Madam Chairman, before, is it Dr. Mayfield?
Yes.
I do have a question. You do
I'm sorry.
represent the special education directors,
yes, ma'am,
across the state, and you have communicated some reservations with this policy, as well as others who are somewhat concerned that we as policymakers are receiving this amendment, if you will, today.
Yes,
and we do, we should be compliant with the Administrative Procedures Act, and the Administrative Procedures Act requires the posting at least 10 days prior to the meeting. This was not done, and quite naturally some may debate me stating, well, the item was on the agenda. But as a policymaker, I have some serious concerns approving something when I have not heard from all constituents. I think I would like to recommend and put in the form of a substitute motion that we defer this until the next meeting so that we can bring others together to have, at least assemble a meeting, say this is the proposal, let's have further discussions, so that when we approve the policy, it can be something that we can Except.
I'm sorry, you made that in the form of a motion?
Yeah, I did offer substitute motion.
And
I second.
I thought I heard you say that. I do want to point out that that is BESE protocol, and that we do change language often when we're here, but that's just a point of clarification.
Well, but
doesn't change your bill, and we're going to move forward with
but
that.
I do want to respond to you. It is a part of the Administrative Procedures Act.
Okay.
And
I don't believe it. Okay. I don't believe it is. But putting that aside, let me describe maybe an alternate perspective to Dr. Mayfield's on this. I believe the line that Dr. Mayfield, and I'm not saying you're objecting to it, you just don't think it should be in this bulletin. And I'm going to read as follows. It is under 405, paragraph D, the final sentence. It says only diplomas. So in other words, basically this law allows for every kid to get a diploma. So we're looking at 100% of kids.
A regular diploma, just a diploma?
A diploma, regular diploma. It then says only diplomas earned by students who have pursued the regular academic state standards and who have earned all state-required Carnegie credits shall be considered regular diplomas in the state and district accountability system pursuant to federal laws and regulations. Now, why did we think that was important? Whether we like it or not, accountability drives a lot of decision-making in the field. And effectively, the superintendents would say, and I would say, you have an accountability incentive to have as many kids as possible eligible for a diploma that counts in the accountability system. I'm going to try to not get complicated here. There are also definitional questions about, as Sean, you raised some of them, about who is in this 1% category and how large a group that is or how small a group that is. In Louisiana, we have a very small number of such students, and Dr. Mayfield has advocated for that. I'm getting to this to say that you can't really say to a superintendent, go implement this, but don't understand what the implications are for accountability. And so we think it's important to have a clear line demarcating those diplomas that count, which is 99%, give or take, and those that don't, which is 1%. I do think you should encourage us to find a way to count the 1% in the accountability system. I also think you should take note that for the first time, because of what these folks have done, Law 1 kids get a diploma. No one's arguing with that. The parents, the kid, they walk away with that diploma. There's a federal law question as to whether or not it can count in accountability. We're pretty clear the answer is no. We may have some semantic disagreements on that. But two things I would take from this if I were you. One, the field does need to understand what this means for accountability. Two, we cannot just accept that this is the limits of accountability. We've got to find a way to count those kids in accountability. And thus, I think we should move forward with this because I think the field needs that guidance. And to Laureen's point, that's why we included it.
Superintendent White, can I ask a question? I just want to be clear on the first part. I'm sorry. Oh, I'm so sorry. Ms. Bradford, may I ask Superintendent White?
Yes, you may.
Forgive me, I'm sorry.
That's all right.
The first part of that is, are you saying that that language says that any student other than a Law 1 student who is put on the alternate pathway under the Act and has the performance requirements set by the IEP team will receive a diploma that can be accounted for in accountability?
Yes.
Then I'm all right with that.
Ms. Moranti?
I just would like to say that this has been one of the most rewarding things for me as a policymaker over the past year and a half, hearing the parents advocate for their children and then marshaling your forces as well as you did with the legislature. I'm so heartfelt. I've heard the most heartfelt testimony from the parents here, and I'm just applauding your efforts. Thank you so much.
Thank you.
Thank you, Dr. Moranti. Ms. Buffy?
Is a substitute motion in order, or we already have one?
I think we already have.
We have one.
Got two, but you can have another.
I thought we could.
I'm going for it then.
All right, go for it.
I have a substitute motion.
But remember, we're doing it in globe, but we haven't broken them out to vote on separately. We're just hearing them separately. But we can vote on them separately.
I have a substitute motion on 1530.
Okay.
You ready? Are you ready?
Yes.
I move the board approve the revisions to Bulletin 1530, Louisiana's IEP Handbook for Students with Exceptionalities as amended, and that the board direct the Louisiana Department of Education, in consultation with special education advocates, to submit a proposal to the Academic Goals and Instructional Improvement Committee to recognize the achievement of high school students accessing the alternate academic standards in the state, district, and school accountability system.
If you have that written, would you please pass that down? Do I have a second? Dr. Moranti seconds. Dr. Moranti. Any questions, comments? Yes, Ms. Smith.
Okay. And it does sound like that y'all have probably gotten this worked out. But when Sean, when you have a conference call with someone in Washington, as y'all did, are y'all talking to the same people? In other words, okay, so
there were on their end and on our end, there were some different parties involved.
What's the name of this group right here?
I mean, the main people we were speaking with were Michael Uden, who is the acting assistant secretary for the Office of Special Education and Rehabilitative Services, and Deborah Delisle, who's, I think, the secretary of ESEA. This time there was legal counsel on that call, as well as Jill Walsh, who is their local and state. I looked him up, like a liaison person. But the primary people are the same people. The other people on the call today were Representative Schroeder and Representative Steve Scalise in Congress, and some of their staff members were involved today, and some legislative policy analysts from Louisiana.
But I guess my question is, so the same people that you are talking to about this legislation, is that the same folks, Superintendent White, that you're speaking with, basically?
I wasn't requested to be on whatever call happened this morning, but I did invite all three of these experts to a meeting with Deputy Secretary Uden, and we had the discussion, and I'm happy to talk to the folks that he spoke with.
So with the motion the substitute motion that's in place right now, do you feel comfortable that moves us in the direction that we need to go with regard to solving the issue?
Yes.
However many motions the last one that was in.
Right.
Ms. Bugby.
Ms. Bugby's motion. Yes. I think we all agree that the accountability system does a disservice to schools serving students with the most significant disabilities, and it disincentivizes them to even allow them. It creates all kinds of issues. I will point out that, because one of the motions I thought I heard was to delay this, and I totally appreciate that, because I hate getting stuff to read. I will tell you, with the exception of Section D, all of this in here is in Act 833 that was passed, and I have a copy of that. And I mean, you could either trust me or not, but I mean, that was when it went to SEEP last week, or a week and a half ago, whatever. The feedback I sent to Bridget and Superintendent White and Aaron Bentley, it was, basically this language would put it in alignment with Act 833. It would make the definitions of who is eligible, it would make the definitions of what IP teams would do, it would make what the department does, and it would correct something in there that I think was an error. It just put it all in alignment. And Superintendent White, I think we all agree that, and they changed a word or two that actually made it, it was all, it put the language exact, almost identical to what's in Act 833. And my point is, with the exception of D, which school systems don't necessarily use, that's how the state will use this information, they are bound to start this on August 1st. And they've been kind of panicked in trying to put stuff in place to implement it. And so even in the absence of, if y'all defer on this today, they're in the position of having to implement all that's in here except for D anyway. And I just want to clarify, the council and I have not necessarily been putting all kinds of stuff. We have a website where is a dumping ground for different information, and I do webinars on Mondays to just talk to them about what their issues are and understanding of things. But in the absence of y'all doing, if y'all did nothing today, this would still take effect, with the exception of D.
Thank you.
I want an opportunity to close before we vote.
All right. Let's try not to be repetitive. Let's try to wrap up.
I have a question. The group, I'm so sorry, I don't know the name of your group. What is the name of your group?
We're just parents.
Okay. Okay, so.
We're not paid advocates.
Okay, no, I'm just, no. And the reason why I asked that question was the name of the group, because some of the concerns that they stated will be my concern as an individual that work in this field. So I guess my question to you, have you guys connected with those parents to hear their concerns, or have you talked to parents in regards to the concerns? Because some of the concerns that they stated, I have stated to some districts as well, which were my concerns too, in regards to the IEP team, some of the things that transpire in the meetings, the parents not being knowledgeable. I mean, it's just, I can go on and on, but I'm not going to go there.
I will say that one of the things we have urged is joint training, and LaTeach is helping us on that. We're trying to get IEP teams, special ed teachers, ODRs, parents, all trained at the same time. We want everyone to know their rights and be informed.
And parents, right. I mean, I met Miss...
I can answer your question. They have not. Okay? They have not.
You can go.
I'm sorry, I can't do that. You'll need to get a card and come back up. I'm sorry, but that's how we have to do it procedurally. I'm sorry. You may get a card and come back. I'm going to allow that. It's not really kosher, but I will allow that. We do need to wrap up at the desk, but I know you've been answering questions. Any other questions from the dais?
Just one quick one.
Okay, one quick one. One quick one.
Okay, and I guess this is for Superintendent White. So if we're basically taking, what is it, Act 833, if we're basically taking the same Act 833, but we're amending slightly one section of that, is that a rule change, a significant rule change? In that it significantly affects the intent of the law?
No, I don't think so. I think there are a couple of, I think it's fair to say, kind of vague areas in the law where you're getting down to these really fine semantics. Regular diploma, modification of standards, credits, and assessments, and what, can you in that universe modify and what can't you? And we're trying in this regulation to bring some clarity to that in the law. That's all that's been done. There's no conceptual modification, as Sean said. It's just a lot of stuff that's been put into the bulletin. But there is a little bit of interpretation, because what you then end up with is a superintendent or a principal or even an IEP team saying, okay, what can I modify and what does that lead to in terms of accountability? And if you don't answer that question, what we've seen is the superintendent saying, okay, well, that leaves me with no guidance. And that's what we're trying to bring today. There is going to be, as Sean alluded to before, volumes, for better or for worse, more guidance about what IEP teams actually have to do. That won't necessarily exist at the BESE level. That will exist at the school level.
Okay, so with the amendment, are we
one question?
Okay. I just want to make sure that we're actually doing what the intent of the law.
Go ahead. Well, I think that I'm sorry, I can't speak. Go ahead.
Well,
I'll yield my time to Ms.
I just would like to make sure that we're moving in the direction that the intent of the law and the intent that the legislator was working for. And I understand that we have to get the language correct to meet with the federal guidelines. But what my question is this honestly the best way to achieve that, the way we have the amendment now? And I guess I'm going to have to ask that to the folks that are sitting at the table that had the discussion this morning.
Please give a brief answer.
You want me to answer?
It could be yes or no.
Yes. yes, regarding students, what the law says, Act 833 says, everything is almost verbatim out of Act 833, with the exception of D. And Dr. Mayfield brought up the point, and I just asked her, and there was one thing that she said, if you took it out, she says, then it would maybe be better, and I can see that is on the third line of that D, is when it says, and the same level of achievement expected of all students. She's, if you took that out, it might make it better. And the federal law doesn't actually say the same level of achievement. The federal law related to graduation requirements says that the regular diplomas, which is the only time that regular is used in that definition, need to be aligned with the academic content standards, which is very different than the same achievement levels. And so that phrase of "and the same level of achievement expected of all students" could possibly be interpreted differently.
So I'm going to cut the discussion off from this group, if you don't mind. I do understand you've been being asked questions, and I appreciate so much your willingness to sit and respond to it. I want to remind the audience this is going out for a notice of intent. You will have 30 days? 30 days? You'll have several days? 20 days in which to respond in writing to any comments that you would like to make concerning this. I don't know that we'll resolve it today, and so we'll say thank you very much for coming, and we'll ask our next speakers, Deborah Shum, Jonette Dunn, Flavia Eldridge, please to come. She's not here. Donna Reno. No, she's just not here. That's all right. Ms. Shum? I don't know.
Now it's on. Okay. Thank you so much, Deborah Shum, Executive Director for Louisiana Association of Principals. And as a former principal and ODR of a high school that had 18% special education students, I can tell you that this is a step in the right direction. There are many students who get to the high school, and because they could not get past a specific test, dropped out. And they are students who had skills. Some were artistically talented, some were very good in the culinary arts, but they could not get a diploma because even though they had a designated specific learning disability, they were expected to make the same cut score on the test that students that didn't have a disability were expected to make. So I think this is a step in the right direction. However, I think we have to be very careful with the implementation of this policy. There will have to be a lot of training that will need to be implemented for those IEP teams, for the ODRs, and I think I heard somebody mention just Mr. Fleming and the Administrative Association for Special Education Administrators, that there will be some planned training. But I also think we have to be very careful about the policy and make sure that everything is clear. So I'm actually want a point of clarification, and I think my point was on D in what we got in the packet, and I think it's in E in this new revision. And it says under E, number 1, within 30 days of the start of the next school year or course, establish minimum performance requirements in the student's IP. And I'm a little concerned about that language, because if a student is a senior, and this goes into effect this year, within 30 days of the start of the next school year, I'm not sure that's right. And I just would like a point of clarification, because I know principals and assistant principals will be sitting in on IEPs, and there will need to be some clarification, because if it's a senior, next year would be too late. So
it's referring back to a previous passage where it talks about assessments that had taken place in the previous year. So the next is referring to the year after the assessment was taken. The assessment, poor performance on the assessment last year is what makes the kid eligible to be put on the alternate pathway this year. So that's why the word next is there. It's in the law.
So if a student is a senior in this year and is taking, let's just say, English 3, and taking it, they might be on a block schedule, they're taking English 3, they would qualify, though, wouldn't they, for
Yes.
this exception?
Well, depends what happened last year.
Right,
Yeah.
but I mean, if they had not passed one of the assessments in the prior years, English 2 or the ones that were needed for graduation, so they would still be eligible according to that language?
If they met the requirements of last year's test,
So when you
they would still be
say
eligible.
the start of the next school year, that's, I guess, to me, that's not very clear.
Well, we can make it clear in guidance. That's the verbatim
Okay.
language. That's verbatim language from the law.
Okay.
And the reason it says next is that it's based on last year's assessment.
Okay.
Yeah.
And then the second question is, in the second sentence, it says the LDE shall make available a list of multiple appropriate assessments and guidance for use in establishing the minimum score requirements on the assessments that an IET may use for this purpose. So has that list been identified, and is it being sent to districts and superintendents and principals? And my main concern is, it's the tie-in for this as well as the tie-in for teachers' evaluation. What is when they set their student learning targets, if there's going to be a change in the assessment, somebody's going to have to know what is appropriate for use in that area. So have they received that?
This was just signed into law.
Okay.
So you're talking about a bill that covers 7 grade levels and every subject. So we have not yet produced the list of appropriate assessments, but we will be, along with volumes of other guidance for IEP teams. I want to just caution everybody, as urgent as this feels, this is like an entire rewrite of what IEP teams do. This is a multi-year implementation. I know no one knows that better than Debbie, but I just want to caution people that we're going to get stuff cranked out quickly, but this is something that the academic guidance on is going to take a long time.
Thank you.
Thank you.
Donna Reno. So this is unusual for you to come back. The reason they had so much time was the questions from the board. So you have 2 minutes.
Okay. I want to refer back to the Act. It says IEP has the right to do this under certain circumstances, provide certain actions under certain circumstances. So it's not a blanket over everybody. And it also talks about this does not guarantee every student a diploma. This is from the bill. So what's proposed right now is giving every student a diploma. My concern right now, if we get mixed up on what is the definition of diploma, regular versus special, advocates keep saying that this is not a special education diploma. This is a regular diploma. When a student is granted a regular diploma that meets all the requirements, FAPE stops. Funding stops. The kid is on the world, outside, working. The minute he drops, they're thinking that if the child is placed at a work and he's working, then he met the needs and that's it. If that student, after being granted a diploma, decides the work is too hard for him, he cannot come back. And this is the tricky part. We're not following the law. The law doesn't say at any point that this guarantees a diploma for each and every student. If we really want to implement the law, why don't we take the law and use it? Because we can't push for something, then come back and change our mind about what it says. It says parents have to know that this diploma does not mean higher education, does not mean a career. So the parent who came and said this diploma means a career for me, the bill said this does not guarantee a career. So why are we going back and forth and changing the language of the bill, as we're supposed to have policies that translate the bill into policy, but this is not what's happening. We're taking words and or and commas and stuff, it's in and out. We can't do that. Either fulfill it completely the way it is, or let's look for another bill. It doesn't work.
Thank you for your comments. Thank you. I want to be sure that everyone on the board had an opportunity to ask all their questions. I didn't really mean to cut everybody short. I just feel like we have heard, and I feel like it's good understanding. We are reflecting the law. We do have a motion on this particular bulletin, and so we need to take a vote on Bulletin 1530. Would we read the motion, please?
Yes, ma'am. The motion that's on the floor right now is by Ms. Bofi, seconded by Dr. Moranti, that the board approve the revisions to Bulletin 1530, Louisiana's IEP handbook for students with exceptionalities as amended, and direct the LDE in consultation with special education advocates to submit a proposal to the Academic Goals and Instructional Improvement Committee to recognize the achievement of high school students accessing the alternate academic standards in the state, district, and school accountability system.
I have a question.
Yes.
What happened to my substitute motion?
If this one fails, then we vote on your substitute motion.
Well, earlier when Ms. Hill and I wanted to bring, or Ms. Smith and I wanted to bring forth a substitute motion, it was said that we were out of order. We couldn't offer a substitute motion.
I can't speak to that.
Now, come on, folks.
I can't. What I know is that I was told that we could offer this amendment because it was on a specific instance.
Madam Chair, may I close before we take the vote?
Yes, you may.
Okay. One of the things I want to do is read from the policy because to answer Ms. Atala's concern, it says a student with a disability is not guaranteed a diploma and shall meet either the standard requirements for graduation or those established by his IEP team to be awarded a diploma. The other thing that I want to say is that our educators are going to be responsible for implementing this law. It's required by law that they implement this act. What we need to do is pass this policy as amended so that we can then start working on the guidance that the superintendent has talked about. Will take us a while, right? Like we have a lot of work to do to get this right. And so Ms. Orange Jones she sees the apprehension on my face, and it's because she asked, how do you feel about this? I feel there's a lot of work ahead to get this right for kids. And so us delaying or deferring is not going to help us move forward with kids. We need to start working on the guidance for our districts, because what's going to happen is if we don't put the guidance out there, then they're going to be left to do the interpretation on their own. And I think that it's our responsibility to support them in this work to make sure we get it right for kids.
Thank you, Ms.
Can I read the motion again? I'm sorry.
Go ahead.
Use it read again.
Okay. On motion of Ms. Bophy, seconded by Dr. Moranti, that the board approve revisions to Bulletin 1530, Louisiana's IEP Handbook for Students with Exceptionalities, as amended. That was the version that was passed out to y'all. And direct the LDE in consultation with special education advocates to submit a proposal to the Academic Goals and Instructional Improvement Committee to recognize the achievement of high school students assessing the alternate academic standards in the state, district, and school accountability system.
All right, we're ready to vote. Is there any objection to the motion? Hearing none, the motion carries. Bulletin 111, 1566, and 741. Any questions or comments on those? We have no public comment cards on those, so we could take those as a group.
Ms. Bradford, I would like to make a statement to Superintendent White. I know Ms. Brophy did the LDE consult with special education advisors. I want to make sure that parents are involved in that process, because I understand you do have community groups. They have their interests, but I do believe we need independent parents a part of that process as well, Superintendent White, because they know the needs of their children as well.
Agreed.
Thank you.
And I have a question. Who is the parliamentarian on this board?
I don't know that we have one, Dr. Beebe. Next item. We need a motion on these three.
I move that we approve.
Second.
All of them?
Yes.
Any comments or questions? Any opposition to the motion? Motion carries. Next item.
That concludes the agenda.
Thank you all for your patience, for your comments, and for your work.
The Educator Effectiveness Committee will convene in 8 minutes.